program, which is essentially the nuts and bolts of the discovery facilitator process for purposes of those who are interested in participating on the panel of discovery facilitators. I know we have some folks here who are litigants and looking at what it's like to be a participant in the program, and that's fine. Just to let you know, though, most of our program topics will be around performing the duties of a discovery facilitator. So you may have seen me in court or not, but as of November of 2021, the Civil Division has a discovery commissioner. That is me. So I hear all of your discovery disputes with just a few exceptions. I don't hear anything in the complex litigation division. I don't hear any of the unlimited jurisdiction cases. So everything else that qualifies as a discovery motion comes to my court, and that includes cases that have been through the discovery facilitator process for reasons set forth in the local rules, or which are exempt. They will come to me. So I have that calendar both Wednesday and Friday of every week. So I'm not only the discovery commissioner, but I also handle the calendars for unlawful detainer, harassment, and small claims in the afternoons every single day. I'd like to go around our panelists, beginning with Judge Maier, introducing each one of us to you, and then as we get your introductions through chat, maybe there's some comments that we'll make about your participation as well, and then we'll get into the meat of the program. Judge Maier.
Hi, good afternoon, everyone. It's strange that I don't get to see you, but I'm smiling at you anyway. So I have a civil assignment. I'm in my second year in civil, and I had more of our limited cases last year. And when Judge Austin retired, I picked up his calendar. So it's been a pleasure to work with everyone in civil. The civil bar for Contra Costa County is amazing. It's a pleasure to work with everyone. But there are, as you know, a lot of cases, a lot backlogged, and we have some incredible discovery facilitators with us that have just done wonders for the court. The fact that so many of you signed up and you're interested in being a discovery facilitator, and I've been looking at your descriptions of yourself, and you all seem just perfect for this. In any case, thank you. That's the main thing I want to say is thank you, thank you, thank you. Our discovery facilitator page on the court website is posted in the link now. I just pasted it in there. It's a 2-page application, and I really encourage you to take a look at the description in the discovery facilitator page. I also just received notice that we do have a backlog, and the backlog is about 7 cases right now. Hold on a second. I could double check that number. Yes, 7 cases right now, and we don't have the number who are currently in the discovery facilitator program, but once I get that, I will provide that to you. Needless to say, if you have any questions, I know Commissioner Dashman and I are available, and we can answer questions as well as the rest of the panelists. So welcome, and I look forward to seeing your questions. I'm the question retriever. That's my assignment. So I shall pass them on. If you put them in the chat, I'll make sure that the panelists see it and answer it. All right, should I turn to Mr. Pearson next?
Sure, thank you, Judge Maier. I'm David Pearson. I'm a partner at Brothers Smith, where I act as outside general counsel for clients. So I do both transactional and litigation. And I have been involved in the facilitator program pretty much since it was announced. I'm one of the early applicants. So I don't know how many years this has been going on now. And with COVID, I'm not sure those couple of years count, but I have been in since the beginning. And I look forward to getting everybody who is an attendee signed up to act as a facilitator, since our county needs numerous more facilitators. And we'll turn it over to Phil Andersen.
Thanks, David. Phil Andersen. I am a litigation attorney. I actually retired from the practice of working with State Farm Insurance Company in-house for the last 17 years. I've been retired for about a year now, but I still participate in the Discovery Facilitator program and thoroughly enjoy it. I served as the president of the Contra Costa County Bar Association in 2017 and was on the board for 8 years. And I have a real desire to kind of help the judiciary and the legal system and to assist people in their disputes. And so I for the last 25 years, I've served as a volunteer pro tem judge, and then for as long as this program has been around. And it's really a great program, and I'm happy to and looking forward to sharing some of the insights from this experience with you.
Nathan, any contributions or?
Yes, thank you, Commissioner Dashman. My name is Nathan Scheg. I'm the current chair of the ADR section of the Contra Costa Bar Association. We're a sort of co-sponsor for today's presentation. Although I have not been a Discovery Facilitator, I've certainly participated in the Discovery Facilitator program, found it extremely beneficial, and it's so important to the litigants and as well as the judiciary to have this program in place. So I'm looking forward to a great program today. Thank you.
Thank you, Nathan. Well, let's get started. I wanted people to know just right out of the box that how important this program is for the court. I mean, I was explaining to our fellow panelists before we got started that if it didn't exist, the workload would be beyond the capacity of any single person full time. I think it would just really tax the judicial resources, and your contributions are really, truly essential. And from the standpoint of the work that I do when I see disputes come through post the discovery facilitation process, which means that the discovery facilitator was unsuccessful in getting the parties to reach a cooperative agreement, and or there was a agreement on a lot of different things, but not on everything. Those discovery facilitator recommendations are so valuable. They are clearly, I'm noticing that the effort that has gone into both the litigants and the facilitator to seek a resolution of their dispute before the court is evident. And the information that is contained in the recommendation is very, very helpful. So that's just the perspective on my side of the fence. I think what I would love to know and pass the baton around our panelists and for you to know is why, and I'll begin with you, David, and why become a discovery facilitator? What, you're doing a service, you're not getting paid for it. It takes time out of your day or your week. What is it that is happening internally for you that makes you want to do this?
Well, much like Phil, I've been involved with the Bar Association here in Contra Costa for an extended period of time. At this point, it's approaching 22 years. And when I relocated my practice from the Central Valley back up here, I wanted to get involved in as much as possible on the professional and personal side. And being involved with the courts was one of the ways to do that. I didn't have time to sit as a pro tem and take all of the classes, but doing the discovery facilitator role was a perfect way to help out. I can see the cases that come in. I decide, if I have time when the emails go out, whether I have the time to dedicate to accepting a case. And I think, for those of us who act as facilitators, it makes us much better lawyers and litigators because we get to see the mistakes that are made, what people are fighting over. And I can see in stuff that I've done in the past where, if I was sitting on the bench and ruling on that, where I went wrong or where I should have made the argument that the other side went wrong. So I think it's invaluable sitting as that neutral to facilitate my practice, and I know it helps the courts out. So when I walk in and the judges thank us for acting as facilitators, it's a good role, and it is a lot less time than if I had ended up as a sitting on the bench as a pro tem, where I know that those people have to spend a significant amount of time too. So all around, I think it helps. It gives me something to give back to the community, and it helps my practice to make me a better attorney and litigator.
Great. And it sounds like, David, it is important, at least for you, that you can make this contribution, but it isn't so overwhelming of a demand on your time or effort that that it becomes a burden. You don't want it to become a burden. And it sounds like this is a great way for people to get involved without having that concern. Is that part of what you're saying today?
Yeah, I mean, under the rules, if people go and take a look at them, we're only supposed to work on any individual case for about 3 hours at most. I think some of us put in a little more, but when the cases are assigned to us, we don't know initially up front how much time it may take. And we have the right as facilitators, once we take a look at it, if the parties are fighting over 200 special interrogatories and all the rest of it, and it's clearly going to take more than a couple of hours, we have a right to refer it back and send the parties directly to you, Commissioner Dashman, or to one of the judges. But otherwise, it gives me the opportunity to see how long I think it's going to take and proceed forward with resolving it. So, the commitment can vary, and it depends on the assignment, and up front, you don't really see a whole lot. And I know Phil takes a look before he accepts, because what ends up happening is, since the courts are so overwhelmed with discovery and it has to go through the commission, the facilitators first, we get a mass email every week or two requesting help. And, anywhere from 5 to 20 cases are attached for us to take a look at.
Right. And I noticed in the chats, one of the participants said, wow, there's a long list of people here. Well, that may be true, but there's no shortage of cases. So despite that, there are a number of people participating today with an interest in becoming a facilitator. Don't feel discouraged, because there's plenty for you to do. Now, Phil, what about your experience? If you could address that question.
Well, I think all of us have a desire to give back. There's a certain need for personal fulfillment, for human connection. Most of us have some time set aside to volunteer, to give back in some way. And this is why I do it. I find that I like that human connection. I'll explain later some of the specifics about how I conduct these, but really it just turns out to be a discussion where both sides are talking, and I just love hearing their voices and the tone. I'm actually studying to get my master's in marriage and family therapy, and so I sit here and I listen, and I'm just like have my therapy hat on as I listen to people talk about their problems, and I'll explain later some of the examples of that. But it's just really fun. Very low impact when it comes to the time it takes. But a high return on your investment of that time, because you just really can do a lot of good in a short period of time.
So you mentioned, Phil, talking about style and what you do. If you could start the ball rolling on that question.
Happy to. What I like to do is keep it very informal, and I like to kind of have them run the show. So what I'll do is I'll get the assignment, and immediately, even if I'm busy, I'll send out a quick email to everybody on that list. And I'll say, hi, I've been appointed to be the discovery facilitator. I would love to have a chat with all of us together on the phone. I'm free this time. Would somebody like to set up a Outlook invite and send out a phone number, and let's get talking. And I don't want to have anything in advance to look at. I won't be deciding anything. We're just going to talk for the first meeting. And then we decide upon a time, and we get that first meeting going, and it really is the same tone. It's like, hi, how can I help you? What's the dispute about? I haven't looked at anything. And then they just start talking. And it's amazing to me how some of the groups have this kind, helpful attitude of deference, and they help each other and they talk kindly to each other. And other people are cutting each other off and interrupting and calling each other names. And it's just, either way, I let it go. I'm not a judge. I don't have to worry about who's next on the calendar. I just let them talk. And so they talk. And sometimes if it gets too bad, I say, well, why don't we let so-and-so have a chance to finish that? And they just kind of keep talking and they get it all out. And they realize if this is one of those bad groups, they're acting like children and they can hear themselves and they've heard themselves for the last 15 minutes sound ridiculous. And it's a wonderful experience for them. And then because I've been doing it long enough and I know what the judges are kind of going to do and how these things sort of turn out, I just say, what would you think would happen if the judge heard this argument, and get their experiences? And then I kind of give them my take on how things might work. And then I try to narrow down the issues to about the last, maybe we do this for about 45 minutes. So that we set up another call. And the next call, we're just talking about very narrow issues. And usually they've agreed on 50%, if not more. And then we're just dealing with some fine-tuned things, and we come back and we see how it went. And by the time we're there, usually they've either solved it, or then I make a recommendation based upon some very narrow issues. So it's a great experience. Like I said, low investment of time, a lot of fun listening to people talk. I do select the assignments ahead of time because I can kind of tell which ones are repeat, customers, return flyers, whatever you want to call them. And I don't want to deal with them. So I'll deal with the people that I know are kind of going to be okay. And maybe David, you could take the harder ones. But anyway, it's a lot of fun. So that's how I do it.
But yes, David, let's hear your style.
So somewhat like Phil, the list of cases goes out and I'll take a look at them and I'll do an initial assessment, looking at who the parties are in the council to make sure that there's no conflict, because I don't want to accept a case and get rejected offhand, because the participants do have a right to reject the facilitator. And so, I don't want that to happen and have to have the case recycled. But I have an opening email that I use for every case that I'm happy to share with people if they need it, that kind of introduces myself and lets them know that, I am not a party to their case. Not a judicial officer, so I have no access to their case file. I know nothing about their dispute. And I ask them to send me, some brief materials on exactly what their dispute is up front. And at that point, then I will frequently see if they want to hold a conference call, or if they are unable to come to some agreement, if they need me to actually issue findings. Depending upon how difficult and how many issues there are, the facilitators have the right to have each party to send a proposed finding. And if there's a lot of dispute, I will sometimes have each side send me their proposed findings that I can use to kind of craft a resolution. Quite a few times, I don't know if Phil has seen this, I'll accept a case and then one of the parties will contact me and say that they're still continuing to discuss it between themselves, and they'll let me know if they need my assistance. And that has not been an uncommon occurrence recently, where for whatever reason, one party has filed for the facilitator, I guess, to trigger the statute and stop, the time running, but then the parties continue to talk and then I never hear from them again. They resolve it internally, which is obviously the best possible outcome of the case, rather than having to have me issue findings. But at the end of the day, if I have to, I've issued findings that are a couple pages long and more detailed on issues, and then off it goes. And I've had at least one frequent flyer case that's come back to me for further resolution on other issues, and another one that came back and the party that lost the first round objected to me, figuring that if they got a different facilitator, they might have a different outcome the second time around. So there are frequent flyers in the program, and I've wound up with a couple of them with varying results. But I mean, I'm fine depending on how difficult it is. And sometimes, some of the times it's definitely been in areas of the law that I know nothing about. And so when the parties actually need findings, I've had to have them educate me a bit, and I've probably spent way more time than were allotted to kind of learn the issues and be able to issue some findings that actually would make sense if Commissioner Dashman had to review them.
All right, that's great. Now I saw in the chat, maybe Judge Maier, there was a question by about Zoom versus telephonically, or how does the mechanics of the hearing work, and what's the preference of the court?
The preference of the court is whatever works best for the parties and the discovery facilitator. We want to make this convenient for everyone. And I think Zoom has been a wonderful tool that obviously exploded during the pandemic, but it also just makes it easier. You don't have to drive to court or drive somewhere to meet with the discovery facilitator. If you have documents, you can scan them and upload them that the facilitator needs to review. So my preference is that you do conduct it virtually by Zoom, and particularly with Zoom, the discovery facilitator, the one that lets you run on and the other one that doesn't, they can see you and they can connect to you. And I think that is helpful. I know it's not quite the same as being in person, but I don't think it's necessary on these sort of discovery disputes.
And
I've
Phil,
always-
what about yours? Are you Zoom or phone only, or what's worked for you?
So I have a setup with Zoom, and I've been able to use that occasionally, but I really just try mostly to just set up a phone call, just because it tends to be a little bit easier, a little bit less formal. I don't have to dress up in the suit, and since I'm retired, I don't like to dress up as much. So yeah, but I can do it by Zoom, but I don't see that there's a lot of difference. In fact, it almost seems, since I'm kind of that casual style, it seems a little bit easier to get people to talk when they're just talking on the phone.
David, do you have a different perspective?
No, I've never used Zoom. It's been a phone call, and the rules give us a lot of flexibility. So thank you to the court for allowing that. And sometimes I will just hold individual calls with each side to see where they're at and what I can negotiate and act more as a mediator, kind of like what Phil has described. And other times, I've held a hearing just over the phone with both of the counsel or however many are involved, getting their input and going back and forth. But, there's a lot of flexibility, and I don't have any opposition to doing Zoom. I've just never had anybody requested or needed to do it.
Great. I've got a question for the two of you. Just jump in, whoever has the ready answer, which is, have you ever been in a situation where you're in a facilitation, you're doing the discovery facilitator process in a case, and one of two things happens. You're completely at a loss on how to address the recommendations. You're just not having a good feeling about it. Is there a way to get help with that? And if so, and if you've done that, what have you done?
I've never actually had help. I've bounced some of my partners just general discovery questions off them without addressing a specific case. But one website that's my go-to, people can Google it. It's discoveryreferee.com, Catherine Gallo Esquire. She has an amazing blog that goes through discovery disputes and how she resolves them. And I really like her writing style and the resources that she provides. So that's probably my principal go-to. Other than that would be Weil and Brown, civil procedure before trial.
Bill?
And I find that most of the, can you hear me okay? I
Yeah.
find that most of the disputes I have had experience with, and maybe it's the way I, handpick the cases that I'm going to deal with, but there are really not that many complicated issues, and it may be just because of the experience that I've had that nothing seems that complicated. But if I do get to a jam, I will throw it back at them and just say, yeah, what is the law on this? And then the next meeting, we talk about it some more, and they give me some of their take on it. And if I need to, I'll look something up. But it's really not. I'm trying to promote the program so that people don't feel like they don't want to join up. But it's really easy. And if you've had any experience at all with litigation and discovery, you're going to do fine. And then throw it back on them and get a little brief or tell them to give you a cite or whatever and make your job easy.
Have either of you ever been in a situation where you started out in the process as the facilitator, and then it either was going to taking too long, maybe you were into your 5th or 6th hour, which is already more than required or expected, and what have you done in that situation if you've had it?
I'm too dumb to give up. I just kept plowing forward and got it finished. So, once I accept it, I'm going to see it through to the end. But up front, if you see that it's going to be an issue, I've referred cases back and I've told the parties that, this is too complex for the facilitators, and I'll issue a set of findings that refers you back to your judge.
Mm-hmm.
I mean, but what I guess I would ask you, Commissioner Dashman, and you, Judge Maier, the same thing, discovery dispute comes to you and you may not know the answer. So what do you do? Because it's probably not much different from what Phil or I would do.
Read the law.
Read the law.
So many of these discovery disputes in my mind come from counsel not talking to one another. That just the regular contact, and I see some work so well together and others just can't seem to agree on the color of the sky. And they're the ones that will bounce from discovery facilitator to Judge Dashman. And thank goodness Commissioner Dashman is doing what she's doing, and eventually to us, and they will fight about everything. I know that I have a tough trial if they're ending up going to trial because they're focusing on things that really aren't that important. But sometimes it's just a personality thing. Commissioner Dashman, your thoughts?
Yeah, I mean, again, it's all in the law, and we also can read between the lines where if somebody's being unreasonably withholding, that tends to be more or less the area where it's a nuanced area where you get into the nuance of just how much is the person that's seeking the discovery within the bounds of the law. And then of course we have to take into consideration the issue of sanctions. Tell me a little bit about your handling of sanctions requests. I do see those in the recommendations. I'd like to know how you've handled those. David or Phil?
I recently had one where there was a question about an IME and whether or not the doctor could impose a cancellation fee for this thing, that would not happen, and the other side was going to have to pay for this. And I did at that one make a recommendation that the fee should be for this, if it's going to be canceled, it's going to be no more than $4,500. And if you had to litigate this thing, there's going to be attorney's fees awarded no more than X. And I actually went way out on a limb, and I probably shouldn't have done it, but I just kind of said, here's the parameters of what I'm recommending the judge would adopt by way of what kind of sanctions you're going to get. And I'm hoping that you'll work this out. But and I tell them up front before I write anything, I say, this is what I'm going to say in the recommendation. It's going to be this. Now, why don't we think about this and come back next week and see if we can resolve some of this? But they know ahead of time what I'm thinking I'm going to recommend by way of sanctions.
David, any comments to add?
I haven't awarded sanctions. I'm trying to think I don't know that anybody in any of the cases I've done has requested them. So, and I'm somewhat unclear under the facilitator rules if we can impose sanctions and if they would even be binding on the parties, or how those would be enforceable between them without actually going before the commissioner or a judge.
So you can make a recommendation about sanctions in your recommendation as a discovery facilitator, just like you can make a recommendation about the resolution of the dispute on the substance side. And I have seen some with recommendations and some without. So it's really tailored to your case, of course.
Well, and if I could just comment again, one of the hopes that I had for this program was to hear from both of you as to what your views were about some of these things, so that we know as facilitators if this is the right thing. Like, do you normally impose sanctions or not? Or do you kind of shy away from that? Or what are your thoughts about contentious behavior in front of you? I mean, can I send a message to the participants that I don't think Commissioner Dashman is going to particularly like what you're doing here? Is that appropriate? But I don't know, because this is new enough with the two judges, that I don't know what your styles are. Is it appropriate for us to ask that?
Ask.
I
Or-
like the question.
Yeah. Go ahead, Judge Maier.
Bill, I would start with, in general, my feeling about counsel is that they just need to be encouraged to rise to their better self. So I avoid sanctions when possible. And I cajole, admonish, suggest, I use all the tools at my disposal to encourage that behavior to cease. I also observe, it appears as though, and I point out what I'm seeing. And I think for the people who are watching, this is a great opportunity for you to understand what it's like to be a neutral, to try and evaluate from the outside how the parties are viewing their cases, whether or not it's distorted, and just how much is personal between the lawyers or a lack of communication, and how much at times you will see what I consider to be underhanded or inappropriate behavior. And for us as the judges, we want to hear from you. Your observations are completely valuable to us. If you are recommending sanctions, I would suggest that you have gone through various levels of determination before you jump to suggesting sanctions, mainly because usually the blood is so bad at that point. What I'm trying to do is rise them out of it. But sometimes the sanctions it becomes necessary. I don't know if that's such a qualified answer. It didn't answer your question, but I hope it helped. Maybe Commissioner Dashman has something better.
Right. So I'm getting the case at the motion. It comes to me as a motion and it leaves as an order. I don't have the case beforehand. I don't have the opportunity to really have that relationship with the attorneys to maybe cultivate some better behavior. So when it comes to me, I really have to make a call on sanctions and also on the outcome, of course. And as you know, the discovery statute has mandatory sanctions in certain situations. So there is no leeway if I'm going to find in favor of moving party, or even the opposing party, there can be a mandatory sanction requirement. And then other parts of the statute, it's discretionary. I always look to the description of how the sanctions request is drafted. The more specific, the better. So counsel who has to at least lay the foundational requirements of their hourly rate and how much time it's spent and what they spent their time on, all of the things that any kind of sanctions request would require. And you as the facilitators aren't really getting that, and you shouldn't really have to get into that as deeply, but you can certainly make a set, you can express a recommendation in the form of, that this case, given, XYZ factors, I would find it appropriate that a sanctions warden would be considered by the court or something along those lines. And you can even say a number if you want. I mean, it's not a binding recommendation. Everything you do is just for information purposes at the point it comes to the court for review. And I'm not trying to minimize it by saying it's just information. It's very valuable information and really critical for us when it comes here. So in that respect, that would be how I handle it. And yes, so I think most of the decisions do have a sanction award attached at some amount. And sometimes the parties will contest not the substance of the order, but the amount of the sanctions, and sometimes both. And then, of course, other times the tentative rulings are not contested at all. So just, I'm sure you've had that experience as a moving party.
So jumping into questions, we have 2 questions in the chat. I will answer the second one first. Someone with a background in both administrative and criminal law asked if it's a hard and fast requirement that the application requires 10 years experience in civil litigation. Your other experience, I believe, would qualify you, Ms. Rivas, and I would encourage other parties or other interested participants to note they don't have the 10 years, but why they have substitute experience that they believe would be sufficient, because I think you would be terrific. The second question I will pass on to the panel, and it's asking whether or not the facilitator would address any documents or information withheld on the basis of an objection, or would that get referred to the court?
So that recently came up in a case that I was helping with. And what happened is that there were some objections that were allegedly waived because they did not respond to the discovery on time. And so there was a question of, do you have to turn over these documents because you waived the objection by missing it by a day or whatever it was? And I know that's not exactly to the point of what that question is, but that's the example that came to mind. And one of the things that I was wondering when I was making my recommendation is, do the judges who are going to be actually hearing this adhere to a very, very strict standard of this, or can they show neglect to get out of these mistakes? And how lenient is the court with respect to certain types of objections, attorney-client, work product, that allegedly was waived because of this type of thing? That may be putting you too much on the spot and asking you to rule on cases that aren't before you. So don't feel like you have to answer that, but that's where I was wondering.
Judge Maier, I don't know if you want to take a stab at that one, but
I'm sorry, would you just finish the last part of that comment?
The question was, how strict are the judges in enforcing waivers of objections because you didn't answer the question on time? And,
Yes.
or can you show excusable neglect that, hey, it was my secretary, I couldn't help it, I was on vacation, or do you say, no, it's waived, turn over all that attorney-client privilege and everything else, or do you give them a chance?
I think it depends on the judge, but I'm the kinder and gentler one. I honestly think that cases should be litigated on their merits, and timing is important, and we must comply with those rules. But when there is some excusable neglect and or just some problem that has arisen, I believe everybody should be flexible in that way. So that's where I would head. If it's, obstinate and just a refusal, there's a certain point where that sanction does need to apply.
yeah, and I would say the one other place where I look is whether it's gamesmanship, and if the parties are using on either side the deadlines to really play games. That does come out in the briefings. You can tell there's a history and the chronology and maybe some other events that have happened in the case. So in that situation, I would take a harder line in most cases of that nature, without giving you a sense of how I would rule specifically on any case. But I think every lawyer knows that good practice policies to adhere to are much more impressive to the judicial officers than otherwise. So what other questions have we got?
I don't have any in the chat right now. I did want to mention, I did receive more notification. There were actually 36 discovery facilitators on our panel, but I think they need to be weeded out. Apparently, less than half respond. Apparently, it's sent out by Michelle Brown from the court. She sends out an email with the information as to the cases that need assistance with a discovery facilitator, and less than half respond. I mean, certainly a response, I cannot do this, it is fine, but she's just not hearing anything at all. So I think I will circle back to the court administration and see if they can send out the email just saying, do you still wish to be on this facilitator panel? And I'm trying to not discourage you from, you say I have a busy practice and there will be some months even where I just can't do this. So long as there's a response, I don't think we would weed you out. I just think it's when nobody responds at all. And we got a question while I was speaking. So I think this is a great question. It's after applying, is there a shadowing opportunity? Dave Pearson or Phil Andersen, would you might be interested in having someone new to the Discovery Facilitator panel observe and work with you on one or more of your cases?
I wouldn't have a problem with it. I guess we'd have to clear it with the parties and make sure that they're okay with that occurring, because it could present an additional opportunity for someone who is playing games to cause issues later down the road and reject the facilitator after some work starts. But
I would suggest a written stipulation.
yeah, or I mean, emails from the parties consenting is all I would need for something like that, but I don't have a problem with it. But
I think it would be fun to have somebody in training mode with me. And like I said, I'm so casual about it. I don't even tell them, hey, if you think you have a conflict with me, then let me know. I just say, hey, let's get together. And if they feel like there's a conflict, they'll tell me. So I'm kind of on the other spectrum of it. If I knew someone like Tamara was interested, I would just call her up and say, hey, I've got one. And I'd tell them in advance. I'd say, could I have somebody shadow? And here she is. But I think it'd be really easy to do that.
And if you want to watch Law in Motion on Wednesday and Friday, you could always come down to court and see what happens after the facilitator program. That's perfectly fine to me also. We're going to be getting close to the end of our program here in just a few minutes. I would love to know from both of you, Phil and Dave, one of the things that we're trying to do and be more attentive towards is trying to let everybody know that does volunteer for the court, either as a facilitator, a settlement mentor, or pro tem judge, how much we appreciate you. And we've in the past, pre-COVID, we had a couple of gatherings in person to acknowledge all the help. I attended that as a participant in the volunteer programs myself before I became a commissioner, and I really enjoyed that. If you were to just say, hey, what is it that I would really like to have happen as a member of a Discovery Facilitator panel, we're open to hearing from you guys what kind of interaction with the bench might be rewarding and maybe even enticing for people who are considering being a facilitator. And we'll think about that.
attorneys always like to spend time with judges. As a longtime member of the Inns of Court, that's one of the big draws for the Inns of Court, is getting once a month to have dinner with a number of local judges. and break bread. So, that in-person thank you that we've done in the past pre-COVID, I think is a big plus that's limited to everyone who's volunteered their time for the court.
I know that there's some ethical issues with the judicial canon of ethics about broadcasting or using your volunteer service to try to get business in the legal community. I don't remember exactly what it is, but I'm not so sure that all the canons of ethics that apply to judges and a judge pro tems where you're sitting on the bench with the robe on apply so much to this program. And so I think it's it's appropriate to say that, hey, I received the award of appreciation from the judges for my service as a discovery facilitator. And you might even put that on your website or whatever. I think people like to know that there's pro bono work going on in law firms and that you can say with some honor and distinction that I'm helping the courts. And maybe tell me, judges, if I'm off base on that, but is that appropriate to be able to broadcast that you received some kind of recognition?
It's absolutely appropriate. And it's appropriate to put on your resume or your CV or your website that you do this sort of service, volunteer for the court. And it sends two messages. One, the pro bono aspect of it, but also the gift that I really see. And I served pro tem for several years before I was appointed. And the instant I was on the bench, I was so delighted. And also I just learned so much because suddenly you take that litigator hat off and you have the neutral on. And you learn so much as to what works in front of a judge, what doesn't, what's appropriate. You see a lot, the motions just come in, and so you get to see a lot of different work as opposed to being constrained by perhaps, especially if you're a solo practitioner, but people in small firms that really have a certain style. And that will have a beautiful effect. So I think the benefit is inherent and also explicit that other clients and or individuals would look at you and say, I bet that attorney knows what appeals to a neutral and what a helpful, let me hire them. What a helpful bit of information for me. So please use it, and we will be grateful that you did.
And I'd go one step further and add that if you have aspirations to become a mediator, aspirations to become a judicial officer, it's invaluable, this experience, towards both getting the skill set that is required for those ambitions, but also just to have an awareness, as Judge Maier said, of what it is to take off that advocacy hat and put on a new hat. And the more of this you do, you'll also find out if you like it, it's not for everybody, but a lot of people find, oh my gosh, this is even better than I expected. So it's a great way to test your own desires and interests professionally.
And Phil, you also, we get to apply with the Contra Costa Bar Association as pro bono. These count towards our pro bono hours for the Bar Association awards. So I know a lot of people who volunteer for the courts track those hours and are, awarded at various levels to our Bar Association. So it matters to the bar and to our courts.
Well, we're just about at a little bit close to an hour, and we'll stop in about 5 minutes. So is there anyone in the chat, on the panel, or in the audience that just let's have a conversation? You don't have to be so formal. Last few words you'd like to have folks hear? Anybody?
I'd like to just conclude by saying that you don't need to worry about spending too much time doing this. Maybe an hour every other week, and you're just doing a great service. And it's not that hard to fit in an hour or two every other week. And it would just take a huge load off if we could get another 15 or so people signed up. So I hope anybody who's listening today will take the opportunity to sign up and try it out.
I agree with Phil. A few more people, it helps lighten the load for all of us. And it really is not a huge time commitment. We don't have robes. We aren't on the bench 8 hours a day deciding stuff. This is a volunteer position. It's a couple hours. And, I've at times taken a month or two off of the program when things come up in work and life. And then, the next time the applications go out, I'll accept a case. So it's not something where you always have to have a case at all times that you're working on through the facilitator program. It's flexible and it fits around your schedule. So don't let any of this scare you away. You should definitely sign up.
Okay, I agree, definitely sign up. That sounds like a great pitch for the program. And I'm hoping that you all have had a chance to have all your questions answered and get some insight into the program and apply. Thank you.
Are we going to
Thank
get
you.
Nathan signed up now?
Yeah, there we go.
You got me excited about it.
Good, great.
Thank you all, especially Commissioner Dashman and Judge Maier for joining in this program and making this happen so we can get some more facilitators on board, and for making it seem a fabulous position and a fabulous process. I just want to let everybody know you get some MCLE for this, so I'll send out the attendance certificates. If there's any to Commissioner Dashman and Judge Maier and Phil and David, if there's any content materials that you'd like to send along to me, I'm happy to forward them to the attendees so that they can have tips and tricks from you all as well. So we'll get that taken care of the next day or so.
I put the links for the website for the Discovery Referee in the chat, and I can send those to you, Anne.
Okay. Okay, great.
Thank you, everybody, for attending. I hope to be reading your Discovery Facilitator report soon.
No, you don't want to read them because that means you didn't do a good job.
Right, exactly. It's all resolved. And the
Okay.
parties just come in and say, we've settled it. We had such a great Discovery Facilitator. Oh, happy birthday, David, in 2 more days.
Oh.
Happy birthday, David. 39 again?
It was actually 5 days ago, but Brian's old, so I'll give it to him. No, 8 days ago. Sorry, June 20th, but close enough, Brian.
All right.